So welcome, everybody. Thank you for being here. I'm Juana Cuetel. I'm the program director at Conectas Human Rights, one of the organizations involved in the book. I would like to start by thanking you for being here today, this Friday morning, and to share with you my happiness for being here, launching this book that was a long process, and a process that was very new also for us as an organization, as people involved in doing comparative research in 3 countries at the same time. I would also like to thank Oscar Vilhena, who you know, who was the leading researcher who had the idea and convinced the others to get on board. Professor Frans Viljoen, who's the professor from the University of Pretoria, who did at the end the amazing work of making it into a book and keep insisting to the author to revise the versions of the articles. And Professor Upendra Baxi, who crazily came to work with us in this amazing project. Also, the 31 authors, I counted them today in the morning. It's quite amazing. There were 31 authors writing in this book. And to the 4 foundation who supported the project, that was, I don't remember exactly how many years, but maybe it was something like 2.5 or 3. Mm-hmm. There were meetings to make it happen, and they trusted in us, and for the first time, the 4 foundation did a project with 3 offices at the same time. So it was not from New York, it was not from Brazil, it was from Brazil, India, South Africa at the same time. It was a joint project for the researchers and also for the foundation supporting that. So Oscar will present a little bit more of what was the idea behind and why we decided to do a research on comparative constitutional law and why we chose those 3 countries. Conectas has been, it's 12 years old, and since the beginning trying to push for this idea of South-South knowledge and collaboration, and especially to try to think the big issues of the human rights agenda from a Southern perspective. And I think this is a very good example of that. Because we don't have the book, the material book, we have the book online, I would like to walk you through the chapters to know what you can find. The book is entirely, it's available online, and for me that's a very happy thing. We were at a certain point dealing with other editorials that were maybe, or publishing houses that were bigger and in London, but they were not going to allow us to put the whole book online. So I'm very happy that the book is online, and I hope, I'm going to talk with Frans to do it also for iPad and Kindle, that then we don't even need the printed version. So let me just walk you through the structure of the book. There's 4 parts. The first one is about the background of the project, is what Oscar will present, why we decided to work with those 3 constitutions and constitutional courts. The second part is the presentation of the 3 Supreme Courts. What is the structure of the Supreme Court of Brazil, India, and South Africa, how the judges are elected, how they decide, how they form their consensus, publish or not their decisions. I have been asking for that to Oscar for a long time, because there are so many articles about that from the Supreme Court of the United States, and it's so difficult to find it about ourselves. So the first part is the presentation of the 3 courts, and also there's a chapter on how they use and apply international law, and especially international human rights law, and that's more comparative between the 3 of them. The third part are the specific rights. And I think it has a perspective. When I read the list of rights, you will see there's women's rights, sexual minorities, freedom of religion, right to health, livelihood, and land. So there's a perspective on economic, social, and cultural rights in the book. And the main part of the book is the discussion of those rights, some in collaborative pieces, so more than one article writing about the 3 countries. Some it's a main article with comments. There's several formats, but those are the rights you will find. And the fourth part are particular players. So we have social movements, the role of corporations, PILI, how do you call? Public interest law litigation, and a nice piece by a Supreme Court judge of South Africa, Jacob. So this is the general vision of the book. It's there, you can use it. We hope everybody will use it, download it, use it for teaching and reading. I hope the book contributes to this new tradition of comparative law from a Southern perspective. My experience is that nothing is more transformative than learning about another country, because then you realize that your country is not the rule. That happened to me. I'm Argentinian. When I came here and I started to read Brazilian court decisions, it was like, well, so my country is not the rule. Others are doing it in a different way. And this idea, this process of making comparison, I think, in a way, make us more tolerant and cosmopolitan. I think the word we are thinking about in Conectas is how we feel more citizens of the world, and nothing more make us more that than learning about other countries. And it's something you need to train. It's not very easy. At the first time, I remember, I still find it difficult to read Baxi. His legal thinking, it's very different to ours, but it's something you train. So more you read, more you understand. It's not the point that we don't do it. We do it a lot, but we do it with the US Supreme Court. So we got to understand the Supreme Court decisions. That is, we need to understand other Supreme Court decisions. And we have here India and South Africa, but I hope we will understand Mexico, Colombia, and others. So this is the invitation for the reading. Let me tell you how we will proceed today. So we will have the presentation by Professor Oscar Vilhena and some questions and answers, and then two presentations from Arvind Nahain from India and Professor Sandra Friedman, and some questions. Those are on women's rights and sexual minorities. And we will have some questions, and then a discussion on comparative constitutional research. And we will have a presentation by Tiago Amparo on video, and also Professor Jet here from the House, and questions and answers. So I give the floor to Oscar.
Okay, thank you very much, Juana. It's an immense pleasure to be here, to have Sandra. It was a quite nice visit, and the coincidence that your visit was in the same moment that we received the electronic version of the book, and Marta put together this conference with Juana, so I'm very thank you, and for you too, Marta. Well, I would only disagree with my good friend Juana that I was the leading researcher on this project. That's not true. I was probably the troublemaker of the book, because I proposed the idea and then I keep pushing people to work. And in fact, there were several people that engaged in a much more intense way than I did in this book, and I would like to recognize this. Probably the person who was most involved in producing this book was Tiago Amparo, who was a researcher at this school, who has worked at Conectas and now is finishing his PhD in Budapest. So Tiago is the one who really engage and move information around and work in some of the chapters and review many of the chapters. Secondly, I would emphasize Frans' role mostly in the end of the book, because there was a health problem with Professor Baxi that in some way challenged us to finish the book, and Frans took the lead and convinced Upendra that he must come back and produce his final chapters. So in the end, we are very glad that Upendra is healthy again, and that Frans convinced him to finish the book. So, in fact, I didn't take any leading role as a research. But I can tell a little bit about why we did this and what was the main concept behind this project. I think the first concept behind this project is that we need to have a more intense, a more comprehensive, a more informed dialogue between countries in the South. I think this was the first point. And this point was since the beginning of Conectas. You know, we would always search for solutions for problems in the South, in the North. So it's very interesting when you try to understand how to solve kidnappings in Colombia, and then you ask for a Swedish researcher that probably lived through 3 kidnaps in the last decades in the country. And so the question is, perhaps we should search for social solutions in the South that would illuminate our practice much more than search for other solutions that were perhaps found in the North, but through other, inserted in different circumstances. So this is the basic idea. And we got the perception that when you make comparisons in the realm of legal issues, most specifically in the area of constitutional courts, then the South is always in underdog position. Why? Because mostly we idealize the solutions that we're taking in the North. You know, their constitutions are the model. Then our constitutions are weird, they're strange. Look at the U.S. Constitution. Originally, we set 7 articles. Look at ours constitutions, 270 articles originally. So ours is a wrong constitution. It's just a bad document. So this is normally how you approach comparative analysis, seeing your position as a position of some ignorance about how we should draft our own institutions. So the idea to compare with other countries who have the same kind of challenges that our countries normally have, perhaps would give us a different perspective in analyzing our own institutions. From my perspective, comparative law, and probably you will be talking about this later and perhaps disagreeing with me, but from my knowledge, and I'm not a comparativist, comparative law as a discipline really got body in the end of 19th century, beginning of 20th century, and perhaps the World Exhibition in Paris was where there was the large conference on comparative law can be set as the point where this discipline appears with a scientific flag on its own, was that with the end of natural law, we need to have a different kind of knowledge in law, so we could say what was right, different what was right and what was wrong. And with comparative law, we would put the European law as the model to be replicated in different countries. And from this time to nowadays, I think, comparative law is used most of the time with a very colonialist perspective. And I think we should revert this process and start to use comparative law in a more subversive way by taking examples, by analyzing much more how legal systems and societies solve their problems than to look only to the design that was decided in some countries. So I think this is the second reason why we engage in this process. We have 3 countries that are not similar at all. They are very different countries, but they have similar problems. The 3 countries adopt constitutions in the moment that they were leaving apartheid, they were leaving colonialism, they were leaving the military regime, and they made the transition, made the Constitution a substantial and important part of the transition process. These constitutions not only were facing the challenge of creating a new instrument, to work as an instrument of government and to limit the state power through rights, but these constitutions have a much wider goal, which is to which was transform the society. So if you take the three constitutions of India, South Africa, and Brazil, the three of them are very ambitious documents that are not just reacting to an immediate past of colonialism, apartheid, or militarism, but they are reacting to a more deep past of their societies of inequality, of injustice inside of this society. So they are very ambitious constitutions, and that's why we had a long discussion if we should call them aspirational constitution, that was the old label attached to this kind of constitutions, or transformative. So the aspirational is a form of calling this constitution something that were not supposed to work really, but just to set a pattern where a symbolic model of how law should work, but that we all know from the beginning that would not work. And our perception is that these constitutions are having enormous effect in the societies that they are regulating. Perhaps they are not fully implemented, as no law in any place are fully implemented. So they are much more than aspirational, they are transformative. They are transforming the societies in which they are operating. So this was the first point. And the second point was, obviously the constitutions are implemented in many different ways by many different agencies, and the responsibility of implementation is divided in many different actors, social actors, academia, and institutions, formal institutions. We decided to focus on one institution. This is a decision. It can be a bad decision, but it was, I think, a legitimate decision in the sense that the courts are having a special role in the implementation of these constitutions, so we decided to focus on Supreme Courts. And this would also make our work more objectively viable in some way. You know, if we could do something with courts, the first idea was, let's do, generically speaking, courts in these countries. This would be impossible to do. So we focus on the Supreme Courts, and we had a long discussion about which kind of cases we would analyze. We tried to select cases that were being decided by the three courts. So we would have really comparing apples with apples, not apples with oranges. So we tried to understand what the cases on sexual minorities were in the three courts. Perhaps all the courts were not having exactly the same kind of cases. They didn't have decided all the cases, but these were issues in front of these courts. So we select a number of cases that could have a comparative, that we could engage in a comparative analysis. And then the third phase of this was to find people that were sufficient courageous to engage on this project. And then we form a group that is not also an orthodox group in the sense that all of them were extremely, there were only academics, but we have a group that is mixed of academics and practitioners, most of them with very solid academic backgrounds, but several of the people involved in these books were practitioners and were involved in some of these cases. So this gave also a special flavor to the book. Okay, so in the end, the book, as Juan already mentioned, the book has an introduction where we debate a little bit about why doing this enterprise, or how could we do this, what is this new approach to comparative law. A second part where we deal with the structures, and then it's not just the Supreme Court structures, it's a little bit about the constitutional structures and the Supreme Courts, and then we have the blocks where we really are really analyzing the cases in themselves. Okay, so then came the final decision, which was to publish this through a very prestigious U.S. or British publisher that has accepted to publish the book, more than one, and Baxi play a very important role and say, no, let's do something that could be free and people could download from anywhere. So that was a very nice decision. I'm very glad about it, that the book is a public good in the sense that everyone could access the book, and I hope it will be used. I will say, as a final word, that in the case that I was presenting before the Brazilian Supreme Court on the case of affirmative action, where the Supreme Court was very concerned about accepting the idea of affirmative action and being labeled in Brazil as an Americanization of the racial debate in Brazil. And I talked with several of the justices and say, well, this will be an inadequate importation of an American problem or American solution to a Brazilian problem. We are not very happy with this. And it was very interesting that by understanding how the question of affirmative action was decided in India mostly, and also in South Africa, the group of lawyers that were involved in this case could point and calm down the Brazilian Supreme Court that this was not an American invention. This was invented much before. Gandhi talked about that before, that the Supreme Court of India had been engaged in cases of affirmative action for decades, that other countries adopt this without U.S. influence. So this was a political, rhetorical argument that I think this kind of book can help. And I know that some colleagues of mine in Colombia have used part of these books to make arguments before the Supreme Court of Colombia, saying, well, in the case, I think was on gay marriage, in Brazil, they are deciding this. In South Africa, this is being the debate. So this has been a very valuable tool for those who are engaging in changing things and making transformative contributions at local level. So thank you very much. I would stop here because I'm much more interested in hearing my colleagues that will speak later.
But I'm going to take some questions.
Okay.
So I'm going to open the floor for questions. They were clapping, but okay. Questions or comments, I'm going to take a round of maybe 3 or 5, and then give the floor to Oscar. I ask you to, if you want to present yourself, introduce yourself, and I don't know if we have a micro. And while the micro comes, I can ask you something.
And feel free to
ask in Portuguese.
If you want.
We translate. While the microphone arrives, I'm going to make you 2 questions.
Okay.
One, if you can tell a little bit how we came into Baxi and the invitation, because I think the first challenge was get to
form a group.
Yes, to know who were the leading authors in India and go there and invite him and convince him. So if you can share with us that experience. And there's a discussion in the book if the constitutions are or not transformative, and the idea that they are liberal, that the liberal tradition includes the idea of some changes, so that they are not a new but a reformed version. I was not in the meeting, so I don't have so clearly if you can share that with us. But now I take the question. You can ask in Portuguese if you want.
Well, I can ask also in English. My name is Constantine. I'm a researcher at PUC São Paulo. And my question is, the idea of transformative constitutionalism is used by jurists in South Africa. But I ask you if this idea, where it does come from, because it's also used in Canada. So does it come from Canada, or where does it start?
Okay. Is there any other question? Okay, there's one here and then one there. Here? Here?
Hi, my name is Virginia. I did a master's at Trinity College Dublin in international and comparative law, and we had a subject called comparative civil rights. And when we were comparing Germany with the United States, there was some sense of identification that in Germany, human dignity is the highest value, and in the US would be liberty or even privacy in some matters. And what would you say would be Brazil's, South Africa, and also India's highest values? Because sometimes in class they would ask me, what would you say is the highest value in Brazil? And I would just, well, human dignity is a part of it, and I had no final question, no final answer to that. And in a way, perhaps you could shed some light on that, or even, you know,
Perhaps not,
raise more questions. I don't know.
Okay, thank you. Here?
Good morning. My name is Bruno Salama. I'm a teacher here, and I'm here essentially to learn. I'm not a constitutional law scholar. My question to Professor Oscar is both to the legal scholar and to the political scientist, which I know he is. The narrative of a transformative constitution would perhaps sound puzzling to those that first envisaged a Supreme Court that would exist to protect minorities. In the following sense, when the Supreme Court is upholding views that are transformative, is it speaking for the minority? That's one possibility. So it's transformative while protecting minorities. Or, conversely, is it speaking for the silent majorities? If we have a political process that is in many ways paralyzed for many reasons, and this is in many ways, I think it's the Brazilian case, but I think it's the case in many places, that we have a political system that has a very hard time to make difficult decisions for many reasons, but probably the most relevant of which being that elections tend to force politicians to very often, try to avoid costs, right? So they want to always be with more comfortable platforms. So if the parliament is silent, which is actually a contradiction in terms, right? Because it's parlare, right? So if the parliament is silent and the political process is not working, then the alternative reading for a transformative Supreme Court is that the Supreme Court is no longer transforming in a way to protect the minorities, but conversely, it is actually speaking for the majorities that are not represented, and the reason being that the political process is failing to produce the consensus that would be necessary. So my question is whether you see the transformative being driven really by the wills of the minority or the majority. Let me illustrate that with two instances that come to my mind. First, gay marriage. I don't know, but I suspect that gay marriage in Brazil, at least, maybe I'm detached from, like what people really think. It's difficult to know. My intuition is that, the population in Brazil, at least here, is not really bothered by it. Maybe there are sectors of the society that are, extremely discontent with, and obviously there are, but I don't see, people so vocal about it. Oh, we're really against gay marriage. So in upholding gay marriage, I'm not sure that the Constitution is really speaking for the majority or for the minority or for the majority. I had another example, it just escapes me, I forgot. But I think the point is made.
Pegamos uma mais só. One more here.
Very difficult question.
No, yes. You need un tratado. No existe essa palavra para dizer tratado.
Hi, good morning. My name is Giovanna. I'm a PhD student at the FGV AISP. And my question is if the text and the constitutional text itself are transformative, or if it's the constitutional courts that are using the text to make the transformations society thinks are needed. That will be the question. Thanks.
Okay. What's your name?
Giovanna.
Giovanna is saving my life.
Easier one.
Yeah, and will help me answer at least 3 of the questions that were Bruno's question and Constantino's question, I think. Yeah, I think what the book taught us was that it's not the courts that are transformative. The constitutions have a normative, a very bold direction of transformation. It has clauses, some of them that are very symbolic. Take the Article 3 of Brazilian Constitution, say the objectives of this country is to eliminate poverty, to eliminate discrimination, and to create a just and free society. So this is a symbolic clause. But what we learn, mostly in the case, I think perhaps the Brazilian Constitution has this in a more organic way, is that if you go further in the constitutions, in the articles 196, 205, etc., which are the implementation of the social rights, for those who are not very familiar with the Brazilian Constitution, then you will see very peculiar mechanisms. Say, well, education is a right, every children has a right to education, and 25% of the tax collected by municipalities and states should be expended in fundamental education. So you have a strong way to make this aspirational constitution a transformative constitution. I think this is the first step. And the generations of this constitution, being the Indian constitution from the 50s, this mechanism were not there. Perhaps then I'm also answering when we start to talk about transformative constitution. Perhaps the Mexican Constitution 1917 is the first one which was a very aspirational constitution because it's a constitution that was supposed to change. The Portuguese perhaps was the most explicit in the 70s, saying this constitution will transform the Portuguese society in a socialist society. So it was a very also symbolic and aspirational way of putting. But I think what the Brazilian Constitution inaugurated in 1988 was, well, if we want to transform, we have to insert in the Constitution, perhaps because in Brazil there was a lot of distrust regarding the Parliament and the executive. And I remember this debate during the Brazilian Constitutional Assembly saying, well, if we want the right to education to be more than just a symbolic right, we have to insert mechanisms to expand the capacity of the state to spend and to have good quality education. So it's interesting. This happened in health. This happened in the area of rights. This happened in many other areas in the Constitution. It could be this very specific clause determining how much you should expend. Could be other mechanisms. So answering all of you, it's not that the judiciary became an extremely progressive entity out of the blue sky. No, the Constitution is ambitious in transforming society and gives some of the ways that society should follow. So this is the first point. Second, what we learn on this research is that most of the decisions obtained in the Supreme Courts were a consequence of extremely sophisticated work by civil society organizations. Okay? There is, I think, a U.S. professor, Epstein, that say, there is not such a thing as progressive courts. You have such a thing as progressive lawyers. So, and I would say not lawyers, but social society organizations, institutions at the Ministério Público or the Defensorias Públicas that increase the cost for the courts not to accept the kind of argument that we make. Because it's just not, you don't have to think of cases as one shot. Normally this is something that starts in lower courts, that academia is reacting, that you create some social consciousness about these cases, that the press is discussing. And then when the case is being decided by the Supreme Court, you have a lot of, you have an intense debate around the issues. So for me, the transformative parts here are the constitutions themselves and civil society organizations that are moving forward in demanding the implementation. Okay, so I don't know if I answered the three of us. Perhaps in some more detailed way, I should answer my colleague.
Main value.
Huh?
Main value.
Oh, wait, no. The three. Then there are the other questions that are very different. Just very briefly. One thing. Then I'm just talking about Brazil. But I have seen in other countries, is that the political system tries to divide the costs of hard decisions. And when they learn that the courts are eager to take, or not eager, but are able to take these decisions, it's obvious that they want to share the costs with the courts. And this happens in many countries, and I think in the US you can see this all the time. And in Brazil, I think President Lula learned this very fast, President Cardoso learned very fast, and Dilma learned very fast. Take Dilma, women with a past very linked to the women movement, and she never talks about abortion, she never talks about gay marriage. We remember the campaign, the cost that talking about abortion had. So if you have a Supreme Court that perhaps could solve this issue without her losing all the conservatives that are on her coalition, well, much better to transfer this cost to the Supreme Court. And there is language inside of the Constitution that make it possible to implement these rights to minorities. So it's not just because a right will benefit a minority that is regressive, because constitutionalism is not about only of majoritarianism. The Constitution is much more than this. Majoritarianism is a part of the constitutional debate, but rights is also a substantial part. And perhaps now I can address the question of value. Well, the Brazilian Constitution, even if I am very enthusiastic about it, it is, my colleague Dimitri Gimolis and I, we just wrote, and several other colleagues that were involved with, we try to say that the Brazilian Constitution is a maximization compromise, compromisso maximizador, okay? Why is a compromisso maximizador? It's not all constitutions are this kind of compromise. No, because you have some constitutions that you make the compromise to leave several things out of the constitutional test because you don't agree, you don't have agreement. So I will take the American Constitution example. There is this nice debate between Jefferson and Madison when Jefferson arrived from Paris and saw the Constitution that was not alike what he thought a Constitution should be. And Madison tried to explain that it was very difficult to agree on substantive issues. That's why they opted to create a more instrument of government. And Jefferson said, well, I understand. This is everyone's second choice. Okay? I would say the Brazilian Constitution is everyone's first choice. Okay, so the compromise was made in inserting in the Constitution all the perspectives. So that's why the Constitution does not have one value that is superior to all the others and organize the others. And that makes very difficult to implement the Constitution when you have conflicts of these rights. So knowing a little bit of the German jurisprudence and the role that the human dignity occupy, I would say in Brazil the human dignity principle does not occupy the same space as it occupies in the German Constitution. Freedom obviously do not occupy the same space that freedom occupy in the U.S. Constitution. It's interesting, and I'm sorry to extend myself, in analyzing the Brazilian jurisprudence in a more systematic way, the Brazilian Supreme Court is much more radical in the sense that it's not compromising the substantive value of a right when it talks about procedural rights. So the idea of proportionality. So, you know, it's always balancing things, freedom and equality, dignity and this, blah, blah, blah. The courts loves this language, uses very loosely, for my taste, but when it comes to procedure, it doesn't make this kind of balances. So the court is very radical and say, well, here we have a procedural thing. We will invalidate all this investigation because there was in the beginning. So it's interesting that the court is more committed to the procedural than to substantive rights. That's the only thing I would say. And because in terms of the equality, I think equality and dignity perhaps are taken more seriously in the area of substantive rights. Freedom is not taken as serious. The courts in economic issues, in freedom of expression, etc., always downsize freedom regarding human dignity. Take the several cases on freedom of expression. When you have this conflict, human dignity is favored by the court. But I would say formal guarantees of due process are more important than both of them. I don't know if I answer your question. Is there something else? Oh, Baxi, just to finalize. So Baxi is this, I don't know how Sandra will react to my comments on Baxi, but for Brazilians who know the Portuguese guy, the sociólogo do direito super importante, Boaventura de Souza Santos for Brazil. Baxi is a species of Boaventura de Souza Santos from India, taking that India is much bigger than Brazil and Portugal. So Baxi is super important as a radical jurist. He has been an important figure both in academia in India and outside. And why we got to him, because I have read his book on the Supreme Court in the 80s, which really inspired my master's dissertation. So when I was for a short period in Oxford, I took the phone book and called Baxi that was living in and say, Professor, I have an idea to make a comparative analysis with the Supreme Court's. And he said, come to have lunch, camarada Oscar. And he called me camarada the whole time. So, Comrade Oscar. And then we invited friends who was, and we made a small meeting in Oxford, and then where I met Sandra. And I think all of us were very enthusiastic about it. He was more skeptical because I think at that time the Supreme Court of India in the last decades are moving in a different direction than when he wrote his first piece, very enthusiastic about this. But we carry him on, and I think that's, I don't know if that was the, okay.
Thank you. So I think I'm going to move to the next. Sandra?
I just wondered if you would be interested in some of the South African perspective.
Oh, yes. On
Yes.
Please.
If you would. Hi, I'm Sandra Fredman. I'm one of the contributors from the South African team. And I thought you might find it interesting to have some of the perspectives on some of those questions from the South African side. So obviously, at the end of apartheid, there was a great need to entirely transform the society. So when you say, was it Canadian or South African, certainly from the South African perspective, there was a lot of influence from Canada, but there was a very, very central, homegrown sense that there needed to be a transformational constitution. So the whole idea of transformation was absolutely central to the new constitution making, given that it was a society. So for those of you that know about apartheid, it was a society which was absolutely riven from top to bottom by a rule of law which was racist anti-rights, anti-liberty, authoritarian from top to bottom. So there was an overriding need to start from scratch and to see a constitution as building a new society. So so the word transformational, certainly the South Africans would think it was a South African, we would think it's a South African idea, just because of the social and historical context. So that's the point about transformation. The point that you made about leaving hard decisions to the courts, which I really found Oscar's answer very interesting, the question very interesting, the answer very interesting, and I thought you might be interested particularly in the South African experience on death penalty. So under apartheid, death penalty, capital punishment, was very much an instrument of the state. It was predominantly used against black people. It was very inhumane and in many ways a symbol of the apartheid state. On the other hand, strangely enough, because of the high levels of crime and the social unrest around during the 80s and 90s, there was still quite a lot of popular support for capital punishment. And in the constitution-making process, there was deadlock. It was actually impossible to reach a decision as to whether the Constitution should ban capital punishment, which already has happened in most European countries, or not. And if you look at the Constitutional Assembly debates, you find a decision not to make a decision. It was very clear that it was going to be left to the courts to decide. And in one of the very first cases, which those of you know about South Africa who know Makwanyane, the court was faced with the question of whether or not to make capital punishment unconstitutional, knowing that there hadn't been any decision. And that was a clear possibility of sharing the cost, that it was left to the court. And I think nobody doubted that, being the court that it was going to come out with making capital punishment unconstitutional. Although there's a very carefully reasoned decision, it's very sensitively put, they definitely left it to the courts to do it. And it's not quite the same story with gay marriage, in the sense that the Constitution does say that under Section 9, it's unlawful to discriminate on grounds of sexual orientation, but the question of gay marriage has been also left to the courts to do, and it was, again, a combination of two questions that you asked about civil society. There was very clear civil society campaigns to take these cases to the court in an incremental way. First of all, get rid of the criminalization of sexual orientation, of homosexuality, and slowly to build up to gay marriage. And in the end, it was the court that decided that there should be gay marriage, and that the legislature was not necessarily keen on it, but it was a possibility of the court, as it were, taking what might have been a decision which was impossible to make in the legislature. And just one more point, not to take too much of your time, but about that same issue, the Indian perspective is also very interesting, because in India there is a much more complex debate about whether the court is actually having the opposite effect of actually paralyzing the legislative process, because the court has taken a lot of decisions, certainly in the 80s and 90s, which insisted on progressive legislative outcomes. And now the legislature can say, well, we can't do this because the court is going to overturn us, so we will wait for a court decision. Now, this is anecdotal. This is what some of the critics of the court tend to say, is that if you do have a court which is too activist, then it saps the energy of political movements and it gets in the way of legislative action. And you would need to do the sociology of that to tell whether it's true, but these things can work in both directions.